I will tell you. I will defend that. First point one. If you could listen to me fully, this point I have noted and I will get back to you. But kindly give me opportunity to present myself. Thereafter only, because the Madras High Court has said you are to discuss in on its merits, not on from some other judgments. Therefore, the judgment of is also included. Valuation report is the subject matter of adjudication by Honorable Division Bench. Therefore, yes.
Our inspection report clearly shows the stand that as per law, you were not supposed to share it.
No, sir, I filed a recall petition. That will be heard tomorrow. You understand? Please listen to me. No, I will complete. Yes. Yes. Yes.
So, since it was very clear, law is very clear that you cannot share. Whenever we become so liberal to make it transparent enough and share to everybody, that time will come. But right now, you are constrained to behave in a manner which is prescribed. It is the asset memorandum and has not to be shared. It is very clear, and valuation report is part of the asset memorandum. So, you are not allowed at any stage. You are saying in your reply that law is silent about it. Law is very clear and loud that you cannot share. So that was the finding of the board and was communicated to you as well. And now the client has endorsed it. So now you can proceed.
Yes, yes. So the entire subject matter of discussion is whether circulation of valuation report is violative of any regulation. That's what I have to explain you. So far as the law is concerned, the same subject matter is before the Honorable Division Bench. And the Honorable Division Bench is superior to a tribunal, it's a constitutional court, and they have told you, unmindful of whatever observations, that means whether it is a constitutional court of single judge or is it a NCLT, NCLAT which has decided, and that is also subject matter of explanation. I will do that, but that is also recall petition I filed. It is numbered as 2, review application 2 of 24. It may be heard tomorrow or day after tomorrow. Kindly note down, sir. This is review application is before the Honorable NCLAT. Review application number 2 of 24. It is numbered also. It will be heard today. Today I mentioned before the Honorable Chairperson. He said because the technical member has retired. I will show you what are the infirmities in that. I will proceed. Screen sharing. Thank you very much for your kind time. So I will focus only on the subject of this valuation and whatever you have also defended. Right. Now, for the moment, the this you can para 2 take out. That is only malified intention. You are not interested. Anyway, I am not reading that. Next. Alright, NCLT, that also. He is motivated. If your lordship sees that 2-3 paragraphs, letters, it is a malified intention that made him file a case against me. Right, next. Which is also part of it. In the investigation process, directly, then where is the procedure? Honorable Supreme Court very clearly said, there will be 2 things. One is a legislative law, another is legislative procedures. If there is both have to be strictly complied with. When the procedure is not complied with, then that also fails. But now, this particular person's matter also is before the Honorable High Court. That's not required as per this topic. Now, this is the sum total, and here the whole thing is why you are trying to investigate it against me instead of using 196 is my objection that has not been answered. Next. Right. Now, the IEA did not carry out any investigation but made false statements. This is my first allegation. Investigation means you should have asked what is the problem. It is NCLAT order came now. It is not there when you are, there was a stay order was there when this gentleman came to when this honorable board came to the conclusion. That is point to be noted. That is where the infirmity starts. Today, it is not the case. NCLAT confirmed. Then the Supreme Court may overturn that. Therefore, that particular conclusion is not to be considered primarily because of three reasons. Reason number one, at the time of deciding my matter, there was a stay of the order regarding the evaluation report. Point number one. Point number 2, as on date, when you are going through this, division bench has told that unmindful of any judgments, including Madras High Court, single judge, which is a constitutional court. The tribunal is not a constitutional court, it is an inferior court. Point number 3, I have every right to appeal. I have appealed the recall petition. Day before yesterday, one recall petition they recalled, saying that they have done mistakes. My petition only. So therefore, this I will establish as infirmity, perverse order passed by the Honorable NCLAT, which I am capable of. But be as it may, so far as the Superior Court is seized of the matter, IBBI is on record that they will not proceed with the investigation. Your order I will show you. So now I am focusing on this. These 3 points must be noted, my lords. Why I am telling you, my lords, is I have to have a defense at the time of this. Last time 815 also stay was granted. The same judgment 4458 stay is there, because when I said 12A5 I am saved by the bylaw, it was not recorded. Therefore I am telling, I am pleading with you to please record my submissions. You can, Lordship can take a decision. So I repeat, this is the first point. Why you should not take NCLAT order which is conclusive and all. No, NCLAT order is not conclusive. Point number 1. As on date, review application 2, recall petition. Recall is different because they have to pass order against that. Review can be dismissed without order. So recall petition will be there they will give reasons. And I still have a right to challenge before the Supreme Court. That is the first point. Point number 2, you are sitting against the order. Order I showed